The Labour Minister's lawyers have argued that the DA's understanding of the Employment Equity Amendment Act is misguided. The party today challenged the constitutionality of the clause which allows for the executive authority to set targets for companies. This is in 18 economic sectors. Here's a quick breakdown of it from Newzroom Afrika's Ziyanda Ngcobo.
Lawyers representing the DA argued that applying blanket employment equity targets nationally when the racial and gender demographics in provinces differ is why it's challenging Section 15A of the Employment Equity Amendment Act. The party says this would cause barriers to work and amounts to a quota.
We say that in 52, even if the impugned scheme is not a quota, it is nevertheless disproportionate and unconstitutional for the following reasons. First, it replaces a system, I've addressed that, it required every employer to formulate and implement an equity plan, tailored for that employer's unique staff complements, operational needs, and the labour market it faces, with a one-size-fits-all mandatory targets that are the same for every employee in a particular sector and region, regardless of how differently situated they may be.
The Labour Minister's lawyer argued against the DA's claim that the executive would have unchecked power when it comes to setting sectoral targets. They contend that unlike in the unamended version of the law, where employers were given the leeway to set their own affirmative action goals, the updated version of the Act now empowers the minister, who does so in consultation with relevant stakeholders.
We know for a fact that, in this case, that targets were drawn in 2023 or so, they were commented on, and they've undergone various iterations. And they've now concretized into, because the minister had to do what they have to do. If you are not happy that the minister has consulted adequately, you don't attack 15A, you attack the consultative process. If you think the targets are irrational and they discriminate against one party or another, you don't come here and say 15A is unconstitutional simply because it allows the minister to set the targets. You go to the targets and deal with them.
Listening in on Tuesday's proceedings was the ANC and its alliance partner COSATU, whose constituency is directly affected by employment equity laws. The Labour Federation says the DA has launched a direct assault on workers and is emboldened by its position within the GNU.
What we see today, GNU, is an attack to the rights of the workers. It is not for the first time we're appearing in this court. Since this GNU, DA itself has come to court more than 2 times, challenging the national minimum wage, challenging the NHI, challenging the BELA, challenging the employment equity. I'm sure they are going to come back to challenge the Companies Act that deals with the issues of the wage gap, to close the wage gap between the lower employee and the senior manager.
The ANC says the DA is representing the interests of the private sector, which has been complicit in flouting employment equity laws.
Many black women, many black people, young people have the qualifications and the requisite skills to occupy positions in the economy. But in the private sector of South Africa, in some of the companies, they just ignored that. And you also find employers in South Africa who also deliberately flout the Immigration Act of South Africa in order not to employ South Africans. So these are things which are happening in the private sector of South Africa. Government cannot just wait and watch.
Judgment has been reserved. For Newzroom Afrika on Channel 405, I'm Ziyanda Ngcobo in Pretoria.